Welcome to Law Sessions. I am Jennifer Housen. In this law session, we will explore human rights in the UK, and in particular, we will look at the history of human rights in the UK, and we'll also seek to draw a contrast with other jurisdictions and see how human rights operate there. Now, most of the times when somebody speaks of human rights in the UK, the thing that springs to mind now, of course, is the Human Rights Act. But before there was the Human Rights Act, you have to look at what the background was in terms of human rights in the UK. But before we do that, I want us to consider human rights in other jurisdictions. When we look at the protection of rights in other common law jurisdictions, so for example, the United States or Canada or South Africa, then we will see that there are different ways in which these jurisdictions, which are common law jurisdictions, actually protect human rights. What you have to bear in mind is that these countries, be it Canada or a Caribbean country like Jamaica or the US or South Africa, all of these countries tend to have a codified constitution. Now, within those codified constitutions, there will of course be provisions for rights in relation to citizens' rights, and as such, the rights that a citizen may rely on as it relates to any kind of state action as against him or her. Now, for its part, the USA has a Bill of Rights. This is 1789. Now, the Constitution of the United States represents a source of supreme and fundamental law. Now, in the United States, the first 10 amendments of the Constitution are more appropriately referred to as the Bill of Rights. And what we see there that it encompasses are things like freedom of speech, freedom of religion and peaceful assembly, a right to keep arms, protection from quartering of the troops, protection from unreasonable search and seizure. And so these rights are by and large firmly entrenched in the United States legal system. Now, we've spoken about entrenchment and what it involves when we looked at the law session in relation to parliamentary sovereignty. And when we talk about entrenchment, it's usually areas which it does require a special process in order for there to be any change whatsoever. So when we look at the Bill of Rights in the US, for example, we see that it is firmly entrenched, as when you consider even the First Amendment, it says that Congress may not make any law which prohibit the free exercise of these rights. And this position is safeguarded by the principle in the case of Marbury and Madison. And the principle is that a law which is in conflict with the Constitution is void. Again, if you go back to the first law session in public law, we see that the vast majority of constitutions tend to have some kind of clause of similar effect, which suggests that if there is a contrary piece of legislation, which is of course in conflict with the Constitution, will be void. Now, the Bill of Rights is binding on state and private individuals. And when you take another jurisdiction, for example, like Canada, we see the Charter of Rights and Freedoms in Canada, 1982, and Part 1.1 of that charter guarantees the rights and freedoms set out in it, and it is subject only to such reasonable limits prescribed by law as can be demonstrated in a justifiable manner as it relates to a free and democratic society. Now, one of the interesting anomalies with the Canadian rights situation is that in Part 1, subsection 1, there is somewhat of a contradiction, because on the one hand, it guarantees rights while it is applying provisions for limiting these rights. Now, as you will see when we come to look more in depth at the UK position, this is more or less a similar situation. It does guarantee you rights, but it is guaranteeing you rights within, of course, a legal framework. Now, the Canadian Charter has effect similar to what you know to be vertical effect, and it applies only to public authorities. So it applies to state and state agencies. Now, if we consider another example coming from South Africa, we see the Bill of Rights there, 1996, and the Constitution of South Africa, of course, is a codified document that arguably reflects the political struggle, which of course ended apartheid. Now, it represents the cumulative desire to create a somewhat modern, multiracial democracy. So, when you look at Section 36.1, it speaks of the rights may be limited only in terms of law of general application to the extent that the limitation is reasonable and justifiable based on human dignity, quality, and freedom. Now, when you look at the Bill of Rights of South Africa, it is primarily directed at the state, but it also has application as it relates to individuals. So by and large, when you look at human rights within the framework of a state, we tend to see that the rights are generally rights relative to the individual and how those rights might be affected by state action. So generally then, the protection of human rights tends to be a central feature of common law jurisdictions, and most common law jurisdictions make provisions for the protection of human rights in one form or another. Now, the common law tradition, of course, is adaptable to different political and cultural environments or conditions. And when you look at, for example, we've touched on the USA, we see that it brings to bear its background of a war, which then they gained independence. When we look at Canada, we see that it represents a somewhat multicultural diversity of that jurisdiction. And certainly with South Africa, again, the Constitution represents or highlights the struggles in relation to civil liberties. Having looked at what obtains in other jurisdictions, what is it that obtains in the UK? What is it that, for all intents and purposes, is the position in the UK? Well, in the UK, by and large, we see protecting of human rights is now more or less enshrined in the Human Rights Act of 1998. But what was the position in relation to protection before the Human Rights Act? Because if you're ever going to approach any question or any discussion on human rights, it must make some provision for what obtained before the HRA. Because what was the reason for the HRA having to come in force? Well, if we go back, there is this Bill of Rights in the UK, the Bill of Rights 1688. Now, I want you to be clear of about the Bill of Rights. The Bill of Rights is not as you know it, for example, in the US, where it talks about a Bill of Rights and it talks about guaranteeing certain individual rights. Please be clear that the Bill of Rights 1688 in the UK is not the same as a Bill of Rights. Because again, an examiner may very well ask you, is it time for a Bill of Rights in the UK? And some law students might think, well, there is a Bill of Rights. No, do not confuse the two. When we talk of the Bill of Rights 1688, this was an act, but it was not to do with rights as we know it, to do with the citizens. So what was it? Well, the term Bill of Rights, it does originate from Britain, but the English Bill of Rights was literally a bill, which as you know is a proposed law that was passed in Parliament in 1689. And what it did was to set out strict limits on the royal family's legal prerogatives, such as a prohibition against arbitrary suspension of Parliament's law, and more importantly, it limited the right to raise money through taxation, among other things. So what it did was it did lay out the framework as to how, for example, Parliament and the monarchy were to operate, but it was not, strictly speaking, a list of specific rights and freedoms for individuals, which is what we know as a Bill of Rights. Instead, when you looked at the UK, when you consider what were rights, you had to look at, for example, certain cases. Now, go back to Dice's, when you look at Dice's theory and the rule of law, where he talks about rights and freedoms are best protected in the common law. There are cases which showed that there are certain things that cannot be done. And indeed, if you look at a case like Entick and Carrington, it does show that there are limitations on, for example, the executive infringing or encroaching on individual rights. So if you remember there, it was about the gentleman and having, or allegedly having, seditious materials, and we see them storming his house. So by and large, we've seen a sort of ad hoc framework with some case law. Equally, there were some pieces of legislation, but by and large, only in the area of labor law, employment law. So when you look, for example, at discrimination laws, for example, between 1975 and 76, there were some pieces of legislation which dealt with, for example, discrimination on the basis of race or indeed gender. So when you look at rights from that standpoint, there was just this fragmented kind of setup. Now, as you look at the UK, again, the Human Rights Act tend to be kind of the reference point, but the UK legal system did afford some sort of rights, as I say before that. So, of course, there was the freedom from unlawful or arbitrary detention, and this was provided for by the remedy which you may know as habeas corpus, and that is the action for false imprisonment. Now, contrary to popular belief, habeas corpus, which means you may hold the body subject to examination, does not say that a person should not be detained unlawfully. That's not what habeas corpus is. It's not saying you should not be detained unlawfully. In fact, you can be detained unlawfully. But what it means is if a person is held by the authorities, he is to be brought before the courts so the legality of his detention can be examined. So that is the point, is that it is about the examination of the legality of his detention. Now, it started out as a useful tool for the king and courts to bring a prisoner to trial, but it grew to be a sort of protection for citizens against unlawful detention by the state. Now, it was widely believed that the protection of human rights in the UK was below international standards. Now, why was this thought to be so? Well, when you looked at the alarming number of cases which were brought against the UK under the European Convention on Human Rights before the European Court of Human Rights, it does seem as if it was well below international standards. Well, of course, the UK, or by and large the UK government, didn't feel that that was the case. Now, if you look at the number of times the UK was, of course, taken to Strasbourg by its citizens, and when you compare that with other states, well, it was only exceeded by Turkey. Now, if you imagine, for example, looking at Turkey is one of those countries who has sought on several occasions to join the EU. One of the reasons they keep saying that Turkey cannot join is because of its appalling record, or alleged appalling record, on human rights. Now, outside of Turkey, the UK was the only other country with as many cases being taken against them in front of the European Court of Human Rights. Now, this, of course, led to the passing and amending of different pieces of legislation, and one of the most fundamentally far-reaching legislation in the English legal system, of course, is the Human Rights Act. Now, the purpose of the act has been to incorporate some, and I will stress some, of the main provisions of the European Convention on Human Rights into domestic law. Now, this was, of course, done predominantly to safeguard fundamental human rights of British citizens, and what we will do is to look at the Act in some more detail. And before we actually start on looking at the Act, I want us to take a very short break, and immediately on our return, we will, of course, press on with looking at the Human Rights Act and the protection of rights in the UK for citizens.